Good day, everybody. I'm Richard Fink, a lawyer who specializes in workers' compensation law. Today is our Injured Workers Legal Side podcast with Richard and Paul. Today we have my legal assistant, Pamela Ford Hughes, who will talk about the issue, which is access to healthcare coverage for injured workers. Pam will deal in part with delays in trying to get this coverage. And Paul Taylor, uh, who will be the main speaker today. Paul?
Yes, I like how you say that. It's because I have some subjects I never shut up about. Hello, everyone. My name is Paul Taylor. I'm a paralegal with specialization in workers' compensation and human rights law. If you want to reach out to Richard or myself and be part of our podcast, you can contact us through the links below. As Richard said, this topic this week is healthcare benefits. And I want to make a distinction, a bit of clarity first to start off with. Unfortunately, this is the foundation of this podcast, is where we talk about the law and specifically injured workers legal side. And I think that's a perfectly titled name for what we do. And what I want to talk about is there's several categories of injured workers, right, Richard? And what it's based on is when you were injured. And you'll often hear injured workers say, "Oh, I was injured in 1980," which is yay for you because the law is a bit better for you. Then it's, "I was injured in 1995," or in my case, 97. That's like, okay, yay, a bit for you because the law changed dramatically. At that time in 1990, the biggest impact change was the way they awarded benefits. They didn't pay you a monthly benefit for the rest of your life kind of thing or anything. They created the benefits and they removed the age factor. They didn't touch healthcare. They left it alone. They said as long as you're receiving workers' comp, you'll get healthcare coverage. But then in 1998, the Workplace Safety Insurance Act, they made major changes. And one of the changes was the cooperation thing, which really angers me from two perspectives. Regardless of when you were injured, there's two sides to that. Like the board always promotes itself and says, return to work. If it's return to work, will really help you. I roll my eyes, Richard, because I know how many times you talk about why don't they just help them, and they don't. Um, and in that, if it, in their opinion, a lot of the times I've noticed since about 2010 was the big shift in the way they changed. Like the one thing I've noticed is the years when they changed the law. But then it's when the board changes its tune or its internal process or the way it thinks. And one of the biggest changes was about 2010. And I observed that in my opinion, and as well as many others. I'm not just talking about myself, I'm talking about many large legal experts. And one of the big shifts was in about 2010 when the board implemented what I call as austerity measures on injured workers. And what really found to be, in my opinion, very troubling, and I'll go out on the limb and say very unethical, is when they started tinkering with healthcare benefits. And there was many aspects of it. Some of it was physiotherapy treatment and other forms of treatment. And then others were what I'd experienced and I heard from others was prescription medications. In many cases, injured workers like myself, we were receiving prescription medications from the board for close to 20 years, and there was no problem. Then all of a sudden, the board said this weird policy of you have to renew your health care, the injured worker does have to renew their health care benefits every 2 years. And I said, well, where's the policy? Where's the law? Utter silence. It's just what we require of you. And I never ever got an answer. I think it was about 6 months, a year ago, when I was appealing their ridiculous decision on healthcare benefits, they just said, "Oh, that issue going to the appeals department, that's not going to go." And I'm like, "What are you talking about?" And they said, "We don't do that anymore." And I'm like, "What do you mean you don't do that anymore?" "Well, we don't have an issue with your healthcare benefits." And I'm like, "No, this is a big deal for me." Because as I remember it, Richard, I took them to court and they won because the judge believed them when they said, we require this of all injured workers. Mr. Taylor fell through the cracks. To which I tried to make a joke and say, well, for my size, that must have been a pretty big crack. I always get really angry when people say that because you're talking about human beings. And it's like, oops, we made a mistake. I honestly don't believe that was the case. What I did learn when I talked to other people like yourself, Richard, was no, what they are actually doing is when you're giving them a hard time, they'll use this as a form of retaliation. And that's very problematic because it just shows you the problem with the board. And not to get off topic about the healthcare, it reminds me of the incident of Alicia. She was an actress, and the board thought she was faking. So they hired a private investigator to follow her around. The most disturbing one was when the private investigator was standing by her apartment door listening while she was in her apartment. Then there was the injured worker in Windsor who accused the board of murder. Okay, that's his opinion, and the board tried to criminally prosecute him. To which the judge said basically, thankfully, the judge, had common sense and went, get the hell out of my courtroom. It's these extremes that are troubling, is what I'm saying. There was the other one, the Curtis case that went to the Court of Appeal, where the judge said, isn't enough you took their benefits away, now you want to throw them in jail. These are things that are an indicator to me when you look at it holistically of a system that has gone crazy, in my opinion. And nothing says it better.
Go back to the medical healthcare.
Yeah, I'm just doing that now. I'm circling back around. Nothing says it better than when somebody needs treatment and care. What I found is you're at this recovery stage, right? You're in like a hump, and you're going to get up to that hump of pain and everything, and you may recover fully if you get the treatment and care. And it's at that crucial stage when the board says, well, no, we're not going to give you anything, or they limit treatment. And then it literally, in many cases, turns into a permanent injury. And that's the most problematic part of that. Then there's the ones that have had coverage, like myself, for many, many years, and then they start playing games with it. And what angers me, Richard, is whether it's an individual, which it isn't, we know this is true, it isn't, it's the system. It's a policy, it's a system-wide issue, is that when that happens, they're never held responsible. The most the injured worker gets on appeal, and correct me if I'm wrong, Richard, is the benefits and maybe some interest. And that shows to me the lack of accountability when the system goes sideways or goes wrong. But the one thing that it's interesting because one of the issues with healthcare, recently I sent you a decision from the tribunal, and it was about cannabis. Cannabis is considered healthcare now, medical purpose for many years since Justin Trudeau, the prime minister with the government, they legalized it as for medical purpose, and then they just said use it for your own personal use. Um, and it is recognized, and it is scientifically been proven to aid in many healthcare issues, including chronic pain. But when you look at the policy for the WSIB, it's very clear the people or doctors who wrote that policy was very clearly opposed to cannabis. No question. Limiting its use and grilling the people and accusing them of drug addicts when many haven't had that problem. And even if they were, that's their choice. You know, when you're dealing with healthcare, the one right that comes to mind that keeps coming back, resurfacing, is the right to autonomy under the Charter under security of person. And it seems that the board has no understanding of that. So when I was at the tribunal with one of my decisions, the legal counsel notified me that somebody is doing a charter challenge on it. I was kind of frustrated because it seemed like I was being invited to make submissions, but they were like, no, we're just pausing yours. Oh, great, thanks. Because I would have liked to have made submissions, and I think others should have been invited, like the legal clinics and Arch Disability in them. So that's my basic spin on. The other thing, like I was saying, was the board policies, and I've mentioned this before, Richard, with you, was in the policies that I've noticed with the WSIBs for some time now, they've been writing policies to retroactively apply to all previous laws. And it's one thing to say, okay, this policy applies. And in the case of injured workers injured prior to 1990, this is how we do it. And then after 90 and 97, this is how they don't. If they want to do something today, like the law the way it is today, they just create a policy that retroactively applies to all injured workers. And they'll say, well, we can do that. When I check the law under Section 159 that empowers them to write policies, it only says to interpret this act, meaning the Workplace Safety Insurance Act. So that's one point that legal reps, when they go before the board for healthcare benefits, if they have an injured worker that is injured prior to 1998, they should argue that point and say, look, this policy is illegal for my client because it only applies, he's injured prior to that, so it doesn't apply to him. It's an arguable point. I'm sure that the appeals department and the tribunal might say, no, you're wrong, you're misinterpreting it. The other point that I would raise is a human rights argument on the policy itself in the way that it's being implemented, right? Because they're depriving you of health care. That's basically all I had to say. Did you want to say something, Pam? I know you've been very
I
silent.
wanted to ask Pam a question, and it relates to one of the appeals tribunal decisions that I found when I was preparing for today's podcast, which is 921/24. In that one, the worker was told she needed psychiatric treatment, and the WSIB was delaying in providing her with the treatment. So what she did was she left Ontario and went to British Columbia, where she got treatment right away. And the doctor in British Columbia was doing a good job in treating her. And then the WSIB said, come back to Ontario. Your treatment now is ready.
Yeah.
And she said, I'm in the middle of this treatment in British Columbia. I don't want to come back. And they cut her off benefits on the basis that when we tell you to get back for treatment, leave what you're doing now and come back to Ontario. And the tribunal said that given that she was experiencing deterioration of her mental health, suicidal thoughts, and inability to cope with daily living, it was legitimate for her to go to British Columbia and get immediate treatment. So my question for Pam is this like a big problem that the treatment's delayed?
Yeah, there is. We just had a file 2 weeks ago where I got a voicemail from a case manager saying, I'm the new case manager on this file. I was reviewing the whole file and realized 6 months ago that your client should have had psychological treatment. They have insomnia disorder and a bunch of other problems. And I said, we've been complaining about this since we were retained because that's part of the problem why this person was not successfully completing their retraining through the WSIB. And this is a thing that we see a lot where the WSIB will say, oh, well, now we have these restrictions for the injured worker. We're going to look at retraining, but we can't get you the medical that you need yet. So you start doing the retraining, and then whenever we can get you the medical, we'll fit that in where it should be. The medical should be a priority. So we see this all the time. Another thing that's been happening a lot is the WSIB has been sending letters to our clients saying, oh, we're allowing an initial psychological assessment. And then once we get the recommendations, we'll look at treatment. Then they'll say something like, oh, go onto our website and pick a psychologist from the website. But years ago, they used to
No.
give you a list. They would give you a phone number. They would say, oh, but you can call somebody yourself as long as they know that you're on WSIB. They don't give the detailed instructions and information. So we have our clients calling me saying, I don't even understand what I'm supposed to do. And then the WSIB kind of goes, well, we sent this letter saying you're entitled to an assessment and we'll look at the treatment recommendations, but they do zero follow-up afterwards unless the worker or the rep is calling. So that's like a huge problem. We've also had the WSIB accuse our clients of delays with medical, and then our clients are calling me going, no, I just said I couldn't do an appointment on a specific day. And then the specialty clinic said, well, the next available time we have is in a month. but then the WSIB is saying, oh, this worker is not cooperating. And it's like there's a lot of grayness going on with that. There's a lot of delays with the medical system in terms of helping injured workers through the WSIB for sure.
Yeah, but this thing where you said, like the law says, you have the right to choose your primary your healthcare person. It does
Hmm.
not say you have the right to choose from this very narrow list that we pick.
Yeah.
And that's very problematic for me. I get very angry with that because what they're doing and what we really know, it's one thing if they were genuine and saying, we've got these different places that we direct pay and they deal with you and it's fine and it's safe and privacy is protected. It isn't, in my opinion. The case manager is calling and this is what I hear from injured workers. The case managers dealing with these medical professionals directly and directing healthcare, and it's very troubling. And honestly, I would caution the healthcare professionals because I actually talked to a very prominent medical malpractice lawyer, and I was telling him what was going on, and he just went, hmm. And it is very disturbing that this is going on. I would say as injured workers is know the law in the sense of you choose your healthcare professional. And one thing I also tell them quickly is you tell the healthcare professional if the board calls, you don't take the call. You tell your receptionist, and correct me if I'm wrong, Richard, if this is right. You tell them if you want anything, you put it in writing, and you'd be more than happy to provide whatever information they need. Then, when the doctor gets the thing in writing, it protects them legally because then they say, "Hey, Pam, if you're my patient, like I'd be a doctor, um, this is what the board sent me. I just wanted to go over it with you, and this is what I'm going to send them." It completely protects the doctor legally in all aspects. This over the phone, yeah, well. No, no, not good. And if the board is saying, well, we want to do things right away. We have email and we have fax. No, you can still do things in writing. We're not back in the 1950s or whatever. So I don't agree with that. I don't agree with the board pushing injured workers to go to their treating people. In fact, Richard, correct me if I'm wrong, it was back in the 1980s when the board had its own doctors. And what was the problem? The ombudsman, the first time ever, issued a report on this on a sub. I can't remember exactly what the ombudsman did, but they don't normally do what they did because the WCB's doctors at the time in Ontario were so biased that uh, they said that, and then the legislature basically went. WCB went, okay, we'll get rid of her, and that's why Ontario's WSIB doesn't have doctors anymore, all but one. And what I just want to quote something. It says in this book that I have, Insurance Bad Faith, this is a legal reference book. One of the elements is bias in the selection and use of experts. So, in other words, when they have their own doctors and magically, and I've heard this before from reps, the injured worker goes to their doctor and it's like, oh, yeah, you can go back to work. You're going to be fine in a week or two. Then it's like the injured worker goes to another doctor, specialist, and they're like, what are you talking about? You never work again. That's a huge issue. And I just want to caution the healthcare professionals because you're putting your own rear end on the line because if you get a really good malpractice lawyer, he's going to tear them apart. They're going to say, well, how does this inconsistency occur? And then eventually it'll come out and say, well, I did it because the board was paying me and I want to keep them happy. And that's not the right answer for the medical profession. I'm sure many reps have great concern about this going on, that the board is controlling it. I mean, that's just my opinion. I don't know if you have anything to say about that, Richard, in
I,
general.
sorry, can I just also say something?
Yeah.
Another thing that's a huge issue is that let's say the WSIB has not decided or has denied medical treatment for somebody, and we know that this person needs medical treatment. So there's already a delay on that side. Then what will happen is, let's say they go to their family doctor and say, I need this medical treatment. I'm on WSIB. They've denied or I'm waiting. They then get referred to a specialist. I would say 75% of the time, if not more, once that specialist knows that WSIB is involved, they will treat the worker, they will do a consultation report, but they will not do anything over and above that because they do not want to be involved in communication with the WSIB. And this is a huge thing. I've had clients call me saying like, oh, I went and got my initial assessment. I waited 8 months to go and see an orthopedic surgeon, and they know I'm WSIB. They won't touch me beyond the
Why?
consultation,
No, but
right?
why are the doctors doing this? Why are the doctors saying, I
Because
want to deal with you?
because in their experience, they have had so much back and forth with the WSIB saying, oh, well, we need clarification on this. We need clarification on that. You didn't do this report properly. We have further follow-up questions that they don't have the time or the capacity to want to help one injured WSIB worker with all of this hassle when they have all these other people that they can help. It just takes up so much time. And then the other thing is I've had clients call me and go, how come my doctor or my specialist has released my information without my approval, which is what you're saying? Or on the flip side, I've had our clients
Well,
go to specialty clinics and say, I want a copy of the report because it's about me. And they said, nope, WSIB paid for it. You got to ask for it from the WSIB. We're not allowed to release it to you.
see, the release of information, this is the problem with the change in law. So if you were injured pre 1998, like WSIAT, it actually says for only for functional abilities, don't ask me why, the doctor has to have the permission of the injured worker before they release functional abilities information. I think it's to the injured worker and to the employer. Like the law in itself is very problematic, and I'm sure it would not survive a charter challenge because in many cases, to my experience in dealing with private, because I do small claims court personal injury stuff, right? And a lot of it you're dealing with parallel cases, meaning workers' comp and private insurance. So, like, you'll deal with disability insurance, slip and falls, and the standard for the opposing side is you're to provide 1 year of medical history for that area of injury, and that's very restrictive. But the board, like I just got off the phone with the WSIB with the injured worker this week, and they said they want 5 or 10 years, and I'm like, what's the reasoning? What's the relevance? And they don't give it. It's because they're as judges will say, you're on a fishing expedition,
Yep.
Mr. Fink, which is really what they're doing. And what angers me, again, getting back to this thing, that's why I say anger, because it is anger, and I'm sure most legal reps that deal with injured workers like Richard and yourself and others are getting very frustrated because the board can do these things because they're not being held accountable. And I remember, I think it was Kendall or someone else did a study of the appeals to the WSIAT, and I can't remember if it was 70 or 80% appeals were overturned. Okay, great. So those injured workers won their appeal. And I'm going back to this again. Was great that I won my appeal. Yay. And if it's benefits, I get interest on the benefits, but that's it. The problem is when it's a systemic issue, or even if it's an individual case manager doing it, there is zero accountability from them doing it again. You know, the system knows this. The board, whoever, they know this, and this is why they do it. In Canada, the courts, the Supreme Court said to the insurance industry, enough. And they created the tort of insurance bad faith. And in dealing in civil law, where you plead this case, you sue for what we call as compensatory or actual damages, right, Richard? I'm saying right, Richard, because he's a lawyer, so he'd know too, correcting me if I'm wrong. You sue for the actual, and you can sue for pain and suffering and all that stuff. But you also can get in this tort additional damages over and above that. It just, when I say damages, I mean suing for monies. And that's that punishment, that's that additional where the Supreme Court had said in Pilot v. Witten, enough, enough of ripping people off. This was a theme that came from the United States with the US insurance industry, where they said, and it's part of this economic policy sprung from the late 90s in Canada and 80s in the US called neoliberalism, which is basically from the corporate side, it's worth the hit, is the philosophy. Meaning, if we deny 1,000 claims and 2 or 3 of them sue us as a private insurance company, it's worth the hit because we saved all this money. The problem is with the WSIB, and correct me if I'm wrong, when they deny claims, where's their little bit of accountability? There isn't any. And they'll say, well, you get interest. No, where is the accountability when the board does wrong in either implementing a policy, either as an individual case manager, which I do not believe that is the case. I'm not saying I love case managers and staff at the WSIB, but I'm smart enough to know how the system works. And they work it from the top down. They're a very top down, like they're a very traditional corporation run. Like most
So let me
corporations
let
today
me
are
let me go
flat.
on to another
Yeah.
rehab issue. So maintenance treatment. And I'll throw this out at Pam. I wasn't even aware there was a policy on maintenance treatment till I started reviewing for today's podcast. And what we see is over and over again is workers being denied continuing physiotherapy treatment. Is
Yeah.
that like a big problem or it's just something
What
that's
do you mean maintenance, by the way? Pam or Richard, can you explain that in case people don't understand?
the policy on maintenance treatment, and it's an administrative practice document. It's not an official board policy. It's dated December of 2005, updated in April 2015. Document describes maintenance treatment beyond maximum medical recovery. In other words, you're as good as you're going to get. So the
Permanent
question is,
injury.
what are you going to get afterwards? With the purpose of preventing deterioration or reducing the use of medication. The purpose of maintenance treatment is not to provide rehabilitation. Maintenance treatment states decision makers must be satisfied based on clinical evidence that treatment is necessary for the following: reduction of pain and medication, increasing level of functioning, stop deterioration, and teaching the worker independent management of the condition. So I see over and over again, and Pam can correct me if I'm wrong, that workers are refused ongoing physiotherapy.
Yeah, they
100%.
oh, sorry, Pam.
No,
I
it's
was gonna
okay.
yeah.
Go ahead, Paul.
I was just gonna quickly say since 2010, in my experience, like I said earlier and babbled on, the board changed and became very aggressive. I'm not talking about, again, individual decision makers. I want to make that clear. It's a systemic policy or process. And it's that issue is that in many ways, they're causing a permanent injury.
Yeah, what I was going to say is 100% of the time, this is what happens. You get a null decision that says you're at MMR, which is maximum medical recovery, which means we don't think with treatment you're going to get any better. So once that is determined, the WSIB will stop the treatment. I shouldn't say 100%. I'll say 98% of the time. So 98% of the time, once you get a null award, you have a permanent impairment, you're at maximum medical recovery. If you ask for treatment after that point, their answer is no, you're at MMR, you're not going to get any better. What they don't realize is you can still get worse and you have a permanent impairment. They are confirming this, which means you have something permanent that requires ongoing medical treatment. So I have clients going, well, why is my physio cut off? Now, what I've been telling people to do is get a letter from your treating medical professional, send it to the board that says, yes, this person has a permanent impairment, but they require this additional treatment on an ongoing basis to make sure that their condition doesn't worsen and to control their pain. And that's my frustration again with the board is their medical treatment and what they give to injured workers revolves around, we're giving you this medical treatment so you can return back to work, so that you can get better, so that we don't have to pay more money into your claim for whatever reason. They don't do it like, oh, hey, you have a permanent impairment. We need to keep giving you ongoing treatment to make sure that you're okay and you can continue living this life. Because again, for the rest of this person's life, they have at least one permanent impairment. So this happens all the time. This has been going on for years that they keep doing this. And it's very, very rarely that it will change.
I
You
think
know,
that reflects what Paul's been saying, which
mhm.
is that there's no repercussions for cutting everybody off physiotherapy.
Accountability.
Yep.
Yeah.
So
And
if you want to save money, if that's your goal at the WSIB, save money, cut everyone off and let people appeal if they wish.
Yeah.
right, because they know in the system. And again, I want to reiterate, and I'm not, you know, uh, I'm being logical when I say this. I don't believe it's individuals. And that's one thing that I found fascinating in this legal reference book was in talking about insurance bad faith. They referenced and said that there is no, in its opinion at that time of writing it, that there was no institutional bad faith, meaning system wide, like there is with the WSIB, in my opinion. Whereas I do, and I just wanted to quote another element of it, and it says harassing, intimidating, intrusive, or deceptive investigative practices. So where you have system wide in the health professional, oh, you're with WSIB, Pam? Okay, I'm sorry, I can't help you. By the way, doctors aren't supposed to do that.
Hmm.
But when we're in a healthcare crisis trying to find a doctor and waiting 8, 9, 12, 15 months for a specialist, good luck. And then
Yeah, just
placing, oh,
let me
sorry.
make, let me make one further
Sure,
comment
go
before
ahead,
we
Fred.
conclude. And that is another thing I found in an appeals tribunal decision 615/24 that the tribunal accepts the opinions of family doctors to indicate further treatment. And what I've been seeing, at least in my view, was that they were requiring specialists' reports to provide further treatment. They weren't listening to family doctors. And yet, here's the tribunal saying you can rely on family doctors for more treatment, which makes it so much easier. As Paul was saying, you can generally see your family doctor in a couple of weeks. You're months away from seeing a specialist to comment on physio. And the final point was chiropractic treatment. My understanding of chiropractic treatment was, they'd allow it for 6 weeks, never more. And yet there's an appeals tribunal decision where they allowed the chiropractic treatment for a few years as it was assisting the worker.
Oh, that was Michelle that did that decision, the one you said 615. She
Right.
mainly specializes in police officers, emergency responders, and that. I think she has a special contract with them or whatever, because I've noticed that with unions and that sometimes they'll retain a paralegal to represent because in the Law Society, in case people, for your information, is Ontario has the Law Society that licenses paralegals that deal with administrative boards and tribunals. And the rule is there is exception. A friend can represent you and stuff like that. Unions can represent injured workers at the WSIB and tribunal. What's funny is there's a contradiction with the Ontario Labor Relations Board that says that if the union doesn't normally represent the union member per WSIB, they don't have to. But yet the law for the Office of the Worker Advisor says the Office of Worker Advisor is not to represent any union members. So that's another topic we can
All right.
talk about is
Well, let's
representation.
leave our podcast there. And thank you all for helping us out today. And hope to see you next week.
Thank
Thank
you,
you,
everyone.
everyone.
Take care.